Welcome, everyone. Thanks for joining us this evening. We are very mindful of, time, even during this pandemic. I know people can be busy during the day and we just want to spend some time with our families in the evening. So we're going to keep this to exactly 1 hour. I'd like to welcome our trustee that we're going to do the Ask a Trustee session with, who is none other than VP of Insolvency at Bromwich+Smith, Shawn Stack. Shawn's been in the insolvency industry for 20 years. He started when he was 10. Let me just be clear about that. Child prodigy, right?
Not quite.
Not quite.
But I did have a fake beard I used to put on at the time. I hooked it behind my ears so I could.
I believe it. Shawn is super passionate, as are we all at Bromwich+Smith, about just normalizing this conversation around debt. There's just so much stigma, shame. It's almost like a taboo topic. And that's why we started the Ask a Trustee series, just so that we can just have a nice, comfy conversation around some of these topics that, really, if you look at the stats, 51% of Canadians are feeling overwhelmed by debt in some way, shape, or form. So it's actually not uncommon. It's actually very, very common. And it is something that we want to be having just a normal everyday conversation around, because it is common, right? And we want to know, what are the tools, what are the resources, what's fact, what's fiction, and how do we, bring ourselves out of debt. So Shawn is very passionate about these things. He has been featured on Bloomberg, CTV, Global, AM 770. Like, I don't think that I could list all of the great places he's been, spreading the good word, just to really add value to Canadians and help Canadians really sort their way through the debt landscape. So thank you, Shawn, for being here. Welcome.
Totally my pleasure. Thanks for putting this on, Tess.
Awesome. Well, let's get to the good stuff, shall we?
Please. Yeah.
Today's topic is how does bankruptcy work? And before we get into that, let's talk a little bit about what exactly the words bankrupt and bankruptcy mean.
So that's a great question. And I think the reason why that's so important as a question is there's within our community, as you know, it's a pretty common word, but it's not a word that we actually appropriately define. So if you're playing a game and you declare bankruptcy, the game is over. The history of the word bankruptcy, it actually means broken bench. And so what used to happen many years ago is you would typically, it would be merchants that would be extending money, or you'd be at the marketplace and you'd go with the to the marketplace with your bench and you'd have your wares. And if you owed money, what would happen is your creditors would get together and then they would effectively hire a trustee. A trustee would come, take possession of all of your assets, so take it off the bench, and then literally break the bench that you had and then put you in jail. They would incarcerate you. And the concept of a debtor's prison is very much wrapped up within our psyches as people. So bankruptcy means broken bench, and it usually was something that the creditors would force upon their debtor. And there would be specific bankruptcy court, and then there would actually be bankruptcy jail, where you'd go to jail if you didn't pay your debts. That fear is really part of the psyche of Canadians. Now, what's important to remember is that was, of course, way back when we didn't have quite the consumer society that we have now. So in every successful first world in capitalism, you have to have corresponding bankruptcy or insolvency laws in order to actually allow creditors to come in and loan money. We need the ability for our citizens to get out of debt. So bankruptcy is a legal action that Canadians will use so that they're able to protect what their assets are, and be able to sort of secure their future. Because the last thing you'd really want to have happen is someone get into a difficult situation with their credit and then be unable to escape the burden of that credit, and then kind of remove themselves from the community, which is sometimes what happens.
So what you're saying is bankruptcy in real life is not like the board game Monopoly. It's not like you go straight to jail and you're ousted from society. It actually is part of the fabric of society.
100%, 100%. In fact, it's so much a part of the fabric of society that you probably know someone that's filed into bankruptcy, but you don't know that they've done that. And the reason being is that there's this huge amount of anxiety and huge amount of shame around being insolvent and filing a bankruptcy, such that we don't have the ability to have these conversations about bankruptcy and debt within the community. So that's why it's really terrific that we're doing stuff like this to help normalize that conversation.
Okay, so here's sort of a myth maybe that you can maybe help us debunk, okay? If someone is bankrupt, basically they didn't keep their promise and they're not really a very moral person, right? Why would we want to encourage immoral behavior?
Yeah. Well, there's a huge, we talked about this previously, this concept of promises versus predictions, right? So we make promises, and the promises are predicated on certain things happening. And in the event that the things that we've predicated happening don't happen, we need to have an ability to negotiate out of those things, and rearrange what the arrangement is. So what a bankruptcy really is about, it's not about the game being over, and it's not about allowing a rapscallion to escape the consequences of their choices. What it's really about, it's about protecting the individual for the benefit of society and for the community. Interestingly, the very first argument in Plato's Republic, which talks about the concept of justice, that's actually brought up. They say justice is paying your debts as they become due. It's interesting that the perspective in that particular case that's put forward, because it's a wealthy person who loans money, right? We should pay our debts as they become due. However, if we don't have the ability to pay our debts, like our financial debts, then what we need to do is we need to renegotiate what those debts are and say, well, I can't do that, but I'm willing to do this. So one of the things that's also important to understand, Taz, is that a lot of people think bankruptcy is just, hey, I'm not sure if you've seen The Office, the show The Office, where Michael Scott says, I declare bankruptcy. And Oscar says,
Great show.
Yeah. And he says, it doesn't really work like that. And it doesn't work like that. It's quite a formal process, not a stuffy process. I mean, it can be. It's a formal process. It's a solemn process, but it's a process of rebirth. And that's really what it's about. So this isn't about being immoral. It's actually about the law. A lot of us as Canadians, when we end up in the situation where we're like, holy smokes, I don't know what to do, and you discover this ability to file bankruptcy, it's surprising. A lot of people think, well, geez, this can't even be real. And it is real, and your creditors know about it. I mean, it's, again, like I said, it's all part of what that system is. It's not about being immoral. It's actually about being practical, and it's about understanding how we got here and where we're going to. And that's actually one of the things in a bankruptcy that happens is there's budgeting that's encouraged to be done on a monthly basis, tracking your income, tracking your expenses. There's a couple counseling sessions that you go to. So it's actually it's quite a great learning experience for individuals, and it's really positive for their families and their community as well.
Awesome. So you actually started to talk a little bit there about, it being a legal process. I want to talk a little bit about that, about some of the, let's talk a little bit about the Act, the OSB. You're going to talk about what that actually stands for. And
Sure.
If we can talk a little bit about, the key pillars of the Act. I don't want to get into too much depth in that, but let's just talk a little bit about what those four key pillars are, who the players are in that landscape, just so that we can understand that, it really is a legal process, and there is legislation, there is licensing, there's a process for complete resolution and all that great stuff, right?
Yeah. So the idea behind bankruptcy, I mean, we've had different bankruptcy acts throughout our time as a country. But what we have, Canada, it's quite advanced, and we're I don't want to say we're the jewel of the insolvency community, but I think we're right up there. We're a very important piece of that particular crown. The Office of the Superintendent of Bankruptcy is a division of the federal government, and what they do is they license individuals to become trustees. So in Canada, there's about roughly 1,000 people that would hold the license that I have as a licensed insolvency trustee. And you're licensed through the Office of the Superintendent of Bankruptcy. And it's a it used to be a 5-year course. Now I think it's about 3 years. And then after you get your designation as a chartered insolvency restructuring professional, you're invited to attend before an oral board of examination where you're amongst your peers and a member of the government and a member of the legal community, and they ask you questions and they to see what you're about. Now, why that's so important is because the integrity of the act and how we apply this act and how it impacts the community is so incredibly important. When we as a people created the Bankruptcy and Insolvency Act, there are 4 principles that were contemplated. The first principle is the rehabilitation of the individual. So we want to help someone get out of a bad place and get them in a better place. And that's, so I mentioned a little earlier, there's these counseling that happens during it. But the very first thing is it's called a stay of proceedings. So it stops all creditors' action. And it's really important to understand that is that telephone calls have to stop, garnishments have to stop, everything stops. And it's the reason for that is because one of the most sacred things that we can have in a free society is the individual. And of course, the extension of the individual, the family unit. So that rehabilitation is really important. The second principle is the control and distribution of someone's assets. So basically what would happen if someone were to file into bankruptcy, it's called an assignment, and their assets would belong to the trustee. It would be our job to take them and monetize them. But again, tied into that rehabilitative aspect, there's certain assets that the creditors aren't allowed to have. And I imagine we'll probably get into this later, but it's very important to understand, don't be redeeming RRSPs and pensions and things like this, because that stuff the creditors aren't entitled to, and it's not to your advantage, and it's not to the community's advantage doing that either. The third principle, Taz, it relates to investigation. And why it's about investigation is we all want to live in a community that allows the honest but unfortunate individual who's overburdened by debt to be able to be freed from the crushing burden of that debt. But we also want to have a mechanism to be able to investigate, did this individual do something that's untoward, right? So did they transfer assets? Did they take their name off of things? You know, they say, well, it wasn't really my house. I always kind of promised it to my wife. So we are able to investigate those things. And if it turns out that there's things that are inappropriate, we'd be able to reverse that and put that back in. And then the fourth and the last one, which arguably for me was probably the most confusing, and I mostly ignored it for the first couple of years working in the industry, was this concept of faith within our system. And the reason why I had such a hard time with it, and largely just kind of put it to the side, is it didn't really occur to me that there'd be faith in allowing someone to escape the crushing burden of their debt, because there's a part of me that was like, well, they should have to pay it back, right? But the reality is, the faith within it, if we didn't have the ability to restructure, I guarantee you no one would be in debt. And what I mean by that is we all have learned lessons from our loved ones because they've learned them the hard way. And if there was no ability to escape our debt, what would happen is when the banks came and said, hey, we're offering, you know, this, your parents would say, that's the last thing that you want to do. Do not deal with them. Now, we are a consumer-based society, and a lot of, as you know, as we know with what's going on with COVID, a lot of the engine of the economy is us as people and consumers. And when that all shuts down, things get interesting, to say the least. So faith within the system allows for mechanisms to review, you know, if you've transferred things, but it also allows people to know that if something does happen, if that promise that I've made to pay this back, if my circumstances change, I have the ability to restructure. And that's super important from the personal side, but also from your creditor side. They want to know, that there's an ability for them also to exact some sort of control as well on this. Because if you're a corporate entity and you're just pulling out the assets here and there, they want to be able to step in and control that.
Yeah, so it's really critical to actually allowing our society just to actually function. It allows finances to flow. It allows trade to happen. It allows consumers to consume and buy, and it allows for that unfortunate debtor who had made a promise but is no longer able to keep that promise to have sort of that exit strategy. And it's all built in a structure that creates faith in the system, that allows that it enforces investigation. There is that rehabilitation. So let's talk a little bit. We're gonna share a screen in a bit, but before we get to that, I want to talk a little bit about, you kind of alluded to it, that there are certain assets that are protected or exempt. So let's talk a little bit about that. And then let's talk a little bit as well about, are there certain things that just don't go away or cannot be included in a bankruptcy? So let's talk about both of those things a little bit.
Sure. So as far as the assets go, what's important to understand is that the Bankruptcy and Insolvency Act is federal. So what that means is it's across Canada. So every single province has this act, okay? Now, what happened though is as Canadians, when we incorporated as a country, we left property rights within the provinces. And so it's very important to understand when it comes to the exemptions that when it comes to your assets, it's important to understand that your creditors can't always have those. So if you're looking at a creditor that's saying, hey, redeem some RRSPs or take a loan out on your home, that's probably or potentially not the right thing to do. And the reason being is certain things are exempt from your creditors. So in Alberta here, you're allowed $4,000 in liquidatable household furnishings, and that's for both you and your spouse, $4,000 in clothing and personal effects. You're allowed a vehicle with up to $5,000 equity, all of your RRSPs, your children's RESPs, because incidentally, they're actually yours, they're not your children, but those are all exempt.
Right.
And you're allowed $40,000 equity in your home. So it's really important to understand when it comes to those exemptions, your creditors can't have those. And it's important to understand that it changes from province to province. So it's important when you're speaking with someone, make sure you let them know which province that you're in, because there's some companies that are across Canada like us, and we deal with all different provinces, and we can assist with each of those different ones.
Yeah, I think that's a really important conversation to have, because I know prior to working at Bromwich+Smith, my understanding was, whoa, don't go into bankruptcy. You're going to lose everything, right? So I think it's really important to talk about the fact that there are exemptions. They may be different from province to province. And yes, you want to look at the specifics for your province, but it's really important to understand that things like your RSP, a certain amount of equity in your home, some of these things that I guess, we've kind of deemed like, these are some of the basics that people just need to be able to, we want to rehabilitate. We don't want to leave someone destitute, right? So this
Absolutely.
is really important. And it's also important to talk about certain things that cannot be included in your bankruptcy. Can we talk about those real quick?
Yeah, for sure. So again, this comes down to that concept of we want to live in a community that allows us to escape the burden of our debt. But we also want to make sure that if there's certain debts that we've incurred, that you can't escape those. So certain things will survive. So the section of the Act that deals with that is Section 178. And so court fines, right? So if the court has fined you, it's because they're trying to curb a behavior, right? So speeding, tickets like that. So those things are going to survive. Spousal support. So if you're required to pay spousal support, you can't escape paying that. Same thing with your child support. That's going to survive as well. If you've assaulted someone and they've got a judgment against you for assault, that will survive. So also, and it's kind of crazy to put in with those kind of things, is student loans. So if you've been a student in the past 7 years, that debt's going to survive as well. Now, you can make an application afterwards if you've been out of school a certain period of time to have it included in a bankruptcy. It's under Section 178.1. But if you've been a full or part-time student within that 7 years, it does survive. Okay.
And another big one that comes up is, they say death and taxes are those are the two things you can't escape from. But there may be something for, as far as like owing CRA some money if we have tax debt.
Oh, absolutely. So CRA is an unsecured creditor. So if you haven't paid your taxes, you're certainly able to restructure that way. Now, a lot of the reason why people think that's the case and that these sort of things survive is because in the event that you are operating a corporation and you bankrupted a corporation and the corporation hadn't paid its GST or it hadn't paid its source deductions for its employees, that would drop onto the individual who then would have to pay that. However, if that individual went into bankruptcy, that would go away as well. So this concept of you can never escape taxes, you can never escape paying taxes, but you can certainly be forgiven for the debt that you owe on your taxes. And the way that occurs is strictly with under the Bankruptcy and Insolvency Act.
Awesome. I just brought up this screen because I know you wanted to talk to it a little bit, which is really kind of the process of a bankruptcy. I think it's important to share that with people, just sort of what to expect. What does it look like? So just a moment here, it's coming back. I just wanted to make it small enough that everybody could see it. Hopefully everybody can see the whole thing here. So do you want to just quickly give us a quick rundown of this process? And then we're going to talk a little bit about other options, because that's going to lead us into next week's conversation, and then we have some Q&A for sure.
Yeah, absolutely. So the very first thing, if we go to the kind of the top left corner there, you can see the couple. They've got this the balls on them. They're looking pretty unhappy, and there's a gentleman there who hasn't grown a beard yet.
Right? What is up with that?
I know. So it's called filing an assignment into bankruptcy, and so you can see what happened there is you would meet with the trustee. In dealing with us, you'd meet with one of our debt relief specialists. We'd gather the information. You'd meet with the trustee, and it's all done now by video, so you don't have to physically meet with us, because as you can see here, I know that the picture's not to scale, but nobody is practicing social distancing.
Right.
So what would happen? You file an assignment into bankruptcy, and all of the assets would vest with us, and it would be our job to take possession of them and then make an inventory, because as you see, if you move down to the path to the right there, you can see there's the first meeting of creditors. Now, it says if required. Now, the reason why we talk about it being if required, it's only required in the event that the individual has more than $15,000 in realizable assets.
Right.
And to be honest with you, Taz, that doesn't happen much anymore. Because we just don't have, not a lot of people have assets that are worth more than $15,000 liquidated. So that means if you were to pay off all the debt associated with it. So you move down a little bit more, and what is showing there is each month during the period of the bankruptcy, you'd be required to track your income and expenses, and you would be submitting these to the trustee. Now, you don't necessarily have to do it on a monthly basis. It all depends upon what your income category is, but you do have to track it on a monthly basis. So we give you a giant pen that's roughly the size of your body to do that.
Right here, yes.
Yes. So the idea behind this, the tracking, is because it's actually used in connection with your counseling sessions that you can see if you just move over there, just behind the desk there. There's 2 counseling sessions that the individual would attend, and you attend that with your spouse as well. So the idea behind the counseling sessions is, again, it's about rehabilitation. So the first one's going to happen usually within the first 30 days. We try to get it done actually like within the first 15 days. Because what we want to do is we want to keep that momentum moving. I know it takes a lot of courage to move forward. So we want to keep moving that momentum forward so that the changes that we're bringing about continue to happen in the life, because that's what this is really about. Rehabilitation is not just about just getting rid of what the problem was. It's getting to the root of it and helping you get to a better place. So the 2 counseling sessions, one's going to happen, as I said, probably within the first 15 to 30 days, and then 30 days after that. And if you follow the path along, it gets to the, excuse me, that the gentleman there, he's saying in around the 8th month, assuming that it's your first bankruptcy, we review everything and we say, have you done everything that's required of you? So did you come to the meetings that were required of you? Did you hand your statements in? Did you give us your tax information? Because we have to file people's taxes during this time frame. And the other thing we're interested in is, what is your income? Now, why this is so important is that if you've made over a certain amount of money, you would actually be required to continue to report your income for a longer period of time. And we'll go to that in a second. But also, if the creditors were wanted to object to your discharge, so if it turned out you made less than the guideline amount, you did everything that was required of you, you just cross that bridge there, and you can see that everyone's jumping for joy, and they're released from all of their debts, save and except those debts that we talked to earlier under 178.
Right.
If, however, a creditor objected to your discharge, or if we had to, exactly, you'd go over here, and you can see that's a kind of a stern-looking individual, that judge.
He grew a beard, though.
He did grow a beard. Yeah, all the stern ones have beards. So the idea behind this is that when you go into bankruptcy, you're actually given a date out of bankruptcy, if you can believe it. When you go in, they set a date that you're out. So if you haven't done what's required of you, or if the creditors want to say, hey, I don't think you should be out, they have to actually file what's called an opposition, and it goes before the court. The court then would review your conduct during the bankruptcy. So did you do what your duties were? And those are all set under 158. And they would consider, what was your conduct leading up to this? So, for example, and we didn't talk about this a little bit earlier, but I've had people say to me, I've had some advice that has told me I should probably just spend all my credit since I'm not going to be able to pay this, right?
Right.
That is probably the most dubious advice I've ever heard. And the reason being is creditors and the court certainly understand if you're going about living your life and you're using credit, it's normal, right? Because we're a credit-based society. And then you've used it up to the date where you've gone into bankruptcy. They're going to have a history of what the use is. If all of a sudden you've just incurred all of this debt before your bankruptcy, the court's going to look at that. Remember how we talked about faith within the system? They're going to say, hey, this is not faith. The reality is this is for the honest but unfortunate debtor, right? So if you're borrowing money and you have no ability or no intention to pay it back, you're going to end up putting yourself in a very bad situation. Reasonably, if you just behave like a reasonable person, then no one's going to really think anything of it. But if all of a sudden you're like, well, I'm likely going to have to go bankrupt, so I think I'm going to go off for one last hurrah down to Las Vegas. The court's likely going to have a problem with something like that. Right. So what could happen if it did have to go before the court? The court would then grant an order, right? So they could grant an order that says, no, you're absolutely done. Okay, so let's say during the time frame of when we did this report in the 8th month and the time we get to court, you've taken care of all of what the issues were. So maybe you just didn't get your counseling done. Then the court we'd say to the court, yep, they've done everything, and then they'd grant an absolute discharge. They could, however, say, so for example, these people that have decided, hey, I'm going to use a bunch of credit. That could be brought before the court, and the court could say, well, you, ma'am, you, sir, are required as a condition of your discharge to pay some of this money back. I don't know what that percentage could be. It all depends upon what the court would say. So they might say you have to pay $20,000 back. Maybe they say you got to pay $4,000 back. So that would be called a conditional order. They could also suspend you in a state of bankruptcy. So they could say you're going to be kept in the state of bankruptcy for the next 2 years. Now, why that's important, Taz, is that the bankruptcy stays on your credit bureau for 6 years after you're done. Well, that's going to push that off more to you, right? Also, when you go into bankruptcy, excuse me, the assignment into bankruptcy vests all assets that you have and that you may acquire before your discharge. So inheritances, lottery winnings, and things like that. So that's what would be happening if they kept it in longer, right? They could also refuse you from a discharge from bankruptcy. So if you used all this money up and then just went into bankruptcy, they could say, nope, you're refused. And you'd have to wait an entire year before you were able to go back to have that reviewed. The other thing they could do, and it's the last one, and it's arguably the worst, and it kind of breaks my heart every time this happens. It used to be called sine die, and now they just call it adjourned indefinitely. And what that means is that the individual has gone into bankruptcy, but they've not done what's required of them. They've not fulfilled the rehabilitative steps that the legislation has said you're required to do this in order to be done. Now, when they say that, when the court adjourns it indefinitely, it means we're not going to hear this again, and we're not setting this date to a future, because they could adjourn it to the future. They could say, hey, we're going to adjourn this 3 weeks and let you take care of some things. If they adjourn it indefinitely, it means they're just not even adjourning it to come back. You're going to have to come back at a future date at your own time. Now, the problem with that is they're also going to tell us as the trustee to close our estate or close our file. Now, what happens is we talked about that stay of proceedings, right? That stops all the creditor's action, and that happens at the assignment. Well, when we're discharged and the individual's not, it's adjourned indefinitely. What happens is that legislative protection gets removed, and the creditors come back in a brutal way back at the individual. So the reason why I say it's kind of heartbreaking, it's heartbreaking because there's been a misunderstanding about how the debt goes away. Mm-hmm. Sometimes the unfortunate thing is sometimes our locus of control is external. So we kind of are motivated by that which is pressuring us from the outside instead of the inside. And the purpose of this legislation is to help facilitate a sort of an internal authority, right? Very much like one of our core values is individual responsibility as a means to empowerment. The court in this process is really about helping recognize sort of where you're at as an individual to help move forward. In the event that someone hasn't done their stuff, we're of course going to be following up with them to try to help them along. But if they haven't done it, the court's going to say, Bromwich+Smith, you got to close this, and it's going to reinstate all your creditors' rights. So it's a pretty terrible situation. So it's important to understand when you go into bankruptcy, everyone has the right to go into bankruptcy, but you have to earn that right for a discharge. And you do that by doing what your duties are. So if we were to say in the 8th month, we determine, no, you actually have surplus income. So you're making above the guideline. We'd go over to exactly where you are there. And what occurs is you would have to continue to track your income and continue to report your expenses. And you'd have to continue to pay some money into the bankruptcy estate. And this would be based upon surplus income, which is based upon how much money you make and a guideline and how many your dependents are, right? So then the same thing would happen. In the 20th month, we would do a formal report. It's called a Section 170 report. And we would say, what's been the conduct leading up to this? What's been the conduct during this? And we'd be making a recommendation. And you can see there, if you hadn't paid all of the surplus income, so if you make over a certain amount of money, but you've done everything else, we just request mediation. So we'd say to you, hey, listen, you understand you owe $2,000. We want to go to a mediator and get this done. The individual says, absolutely. Interestingly, sometimes it's just done by email, type back and forth. You make your payments on the mediation, you can see you cross it and it finishes. There can be the same situation though at that time, just as we said in the 8th month. There could be an objection. That objection could be from our office if someone hadn't done their duties, from the government if the government was concerned about some conduct, or it could be some of the creditors saying, hey, wait a second, I want this to go before the court and I want the court to hear this. And then the exact same situation that we had kind of discussed before would happen there, where the court would review things and give an order, and provided that you complied with the order, you'd receive your discharge from your debts. Now, when you look at this, of course, you can see there's a lot of moving parts. It's a certainty of a process, but it's not a certainty of an outcome. And that's why bankruptcy, although it's a wonderful legislative tool, there's what's called a consumer proposal, which is what most Canadian citizens will elect to do. Now, what's important to understand with a proposal, and I'm sure we'll do a show like this on a proposal, but what's important
next time.
Is gorgeous. The proposal just has to be better than a bankruptcy. So what we have to look at is we can estimate what we think might happen in a bankruptcy, but it's very important to understand if someone's willing to tell you precisely what's going to happen in a bankruptcy, you should be tinging something going, hey, wait a second, how do they know what the outcome is going to be? Okay.
Right.
So there's a certainty of a process, but not a certainty of an outcome. You could look, and historically, the person might say, well, this doesn't happen very often and this doesn't happen. But anyone that's giving you guarantees this will occur, that's something that you should really, it's sort of like talking to a doctor says, I guarantee all of this is going to change for you. And it's like, well, that's a guarantee that can't be kept.
Perfect. Okay, so it's Q&A time. If anyone has a question, feel free to type it in the chat or unmute yourself. We've had a few questions come in, so I'm going to start with those until I start to see something coming in the chat box, or if somebody unmutes themselves, hopefully I will see that pop up. So the first question is, is there a cost associated with filing into a bankruptcy? And if so, what's that cost?
So the Office of the Superintendent of Bankruptcy issued a directive. Okay, so what the directive talks about is that, and really under the Act itself, is a trustee should be paid from the money that's recovered in the estate. Okay, so there's certain money that has to be paid in depending on what your earnings are. So if you make over a certain amount of money, you have to pay some of that in. However, if you make less than that, what's going to happen is a trustee may say, well, I'm not going to take this on unless you guarantee what my fee is. Now, this is where things get quite interesting, because the fee arguably isn't there. There is no fee. The trustee is supposed to be paid from the assets in the estate. So really what they're saying is, I require you to guarantee a certain amount of money that's in the estate. Now, Taz, that number is roughly $1,600. Okay? Any money that's over and above that, it starts to create a dividend for your creditors. So if you're paying more than $1,600, then you're creating dividends for the creditors. And that's actually arguably what you're doing is you're making payments in connection with your wage, which is under Section 68, and it should be a 21-month bankruptcy. So if you're talking to a trustee that says, well, you have to pay my fee, what you should be crystal clear with them is you should say, okay, I understand that the fee is $1,600. I'm prepared to pay that. But what if you get money from other sources? Will you give me my money back? Will you give me this guarantee back? And if the answer is no, I would suggest they talk to another trustee and another trustee until such time as they find that trustee that says, of course I will recognize this guarantee, because the trustee should be paid from the money in the estate, and the citizen should not be required to pay more money that creates dividends for the creditors. It's certainly reasonable for a trustee to say, well, I don't want to take this on unless you guarantee what my fee is. But what's that fee? It should only be $1,600, unless they're making above the guideline amount, right? In which case, again, it's a calculation that's based upon surplus income.
Awesome. That was great. Thank you so much. Another question that came in is, how does, if I file into bankruptcy, what does that do to my spouse or my partner?
Yeah, that's a great question. Nothing. Okay, so we're separate legal entities. It's till death do us part, right? So as I like to remind my wife, she's always got to laugh at my jokes, but she certainly doesn't have to pay my debts. So in the event that your spouse has guaranteed the debts or has been issued credit cards that are in his or her name, then likely they're going to be responsible for that. But we are separate legal entities from our spouses. So that it's incredibly important to understand that just because your spouse has gone into bankruptcy, you don't have to. Now, the other thing is the trustee may say, well, I need to know what every member of your family unit is earning, okay? And arguably, that's true, right? Like you are, if you go into bankruptcy, you're required to disclose to the trustee what the family unit earns. But the family unit, the members of the family unit can refuse. They can say, I'm not telling you. And if that's the case, then there's an adjustment to the calculation that the trustee does. Sometimes that's not to your advantage, right? So basically what happens is it cuts in half if the spouse isn't reporting their earnings. So sometimes it's actually harmful. And again, it's designed to balance things out. But I bring this up because, again, when we look at rehabilitation and the protection of the family unit, a trustee cannot compel the spouse to provide this information. We can interview them. But in my 21 years or what have you, I've never done something that I've never heard of it happening. I mean, there's that ability, but don't get in fights over this stuff, guys. Like if it's like, well, hey, listen, that's your debt. You've got this here. Because, as you know, some of these things come from illness, and an illness that unfortunately in the community that happens right now can be addictions. And you have a spouse that has an addiction illness, and they get into a whole bunch of trouble, all the debts on them, and they're coming out of that recovery, and they've dealt with that sickness, and they're rebuilding their relationship with their spouse, and they're rebuilding their relationship within the community. And if it puts a bunch of stress on to say, now your spouse is to tell you what the earnings are, no, they don't. Have a letter that says, I refuse to provide my earnings.
Just quickly, a question came up about joint debt, if both spouses have joint debt. And I feel like you did answer that earlier, but if you just want to state that again.
Sure. So if spouses have joint debt together, then provided that the majority of the debt is together, you can actually file a joint bankruptcy. Sometimes it's not really to the advantage of the spouses to do that, but they are free to do that if they would like. Really what that comes down to is we'd review it with them. But, if one spouse has been bankrupt before and the other one hasn't, wouldn't make a lot of sense to file it jointly, because one bankruptcy would be 24 months or 36 months and the other one would be 9 or 21. So.
Right. Awesome. Thank you. I'm going to get to another question that we got on here. Are there other options? Of course there are. We kind of talked about them in one of our other webinars, but options besides the ones that are under the Insolvency Act. So besides consumer proposal and bankruptcy, clearly there are other options, but at what point does it make sense to choose this option, the consumer proposal or bankruptcy option?
So yeah, absolutely. There's other options. So there's essentially, I like to think of it as there's two, right? So there's informal and there's formal. So informal is negotiating on your own. So if you just try to negotiate on your own, and that's great if you have one creditor, maybe two creditors, small amounts. Then there's more formal ones where you're actually, you'd be using, you could do what's called a debt management plan, or sometimes it's referred to as debt pooling. It uses provincial legislation where you pay back 100% of the debt, usually at a reduced interest rate. There's also what's called the orderly payment of debts, which is similar. It's 100% of the debt at a reduced interest rate of 5%. Now, what's important to understand about this is these are voluntary programs that the creditors participate in. So they can say, I don't want to deal with this. Whereas when you're looking at a proposal or a bankruptcy, it's forced legislation. It's not a question of someone saying, I don't want to deal with this, because they're stuck with it as the creditor.
Okay, another question that's come up since you just talked about the choice. Consumer proposal, bankruptcy, are they both client's choice unless a creditor forces the client into one or the other?
Yeah, absolutely. So a bankruptcy, you could be petitioned into bankruptcy. And there's a section of the act, there's like 10 different things that if you did one of these things, a creditor could go to the court and get a bankruptcy order petitioning you into bankruptcy, which would essentially vest your assets with the trustee. Now, again, in Canada, we have not distinguished between corporations and with people when it comes to when it comes to our Bankruptcy Act. It's always the same. So the petitioning aspect is usually just with corporations. It's very rarely that a creditor will petition an individual into bankruptcy, unless that individual has tons and tons and tons of assets that would be considered non-exempt. that they would be able to control in a bankruptcy. In which case, usually they would probably want to be talking to the individual first before they do something like that. So it's very unlikely. So to answer the question in a much shorter fashion, yes, it's the choice of the citizen to do this.
Perfect. We have 2 more questions and like 8 more minutes to go. People are being given government options, right? Like CERB and things like that, which are not being taxed at source. Later, it will come up. There will be taxes owing on it. So, will people be able to include their CERB taxes and things like that into a bankruptcy down the road if that were to come up?
That's a great question. So if it relates to not paying sufficient taxes, absolutely, right? Because all taxes are included. If, however, it's relating to you receive something when you ought not to have received it, right? This is one of the things that would survive. Anything that relates to fraud or misrepresentation. So if it's the case, in fact, I read something in the news where you might have seen it yourself. It's saying that the government is taking the position, there's no one to even investigate if someone's kind of putting this stuff false through. So by no stretch of the imagination doesn't mean later on you could go bankrupt on that. Because if you've been dishonest and you've received this, we talked about faith within the system, to allow someone to escape the consequence of paying that back would be catastrophic to our system. So that would survive.
Awesome. Okay, and the last question. Oh man, sometimes we just get these questions that put a little lump in my throat. This is one of them. It's one that came through on email. Okay. Okay, so it's kind of more of a statement, and the statement is, I've heard that a trustee doesn't have my best interest at heart. The trustee just wants, the best return for creditors. The trustee really works for creditors, doesn't work for the individual. So why would I even bother going to a trustee when there are other options and there are people that actually represent me?
So it's a fair question. And it is a bit of a doozy, because the problem with that perspective is that, and with all lies, there's an element of truth, and there's and with every truth, there's always just a little bit that could be a little more truthful. So what that and I mean this with all respect to whoever sent this in, really what they're saying is that the trustee, as an officer of the court, doesn't have their best interest at heart. Now, here's the thing. The law is at the heart of the law is at the best interest of every citizen. Now, when you're suffering the slings and arrows of the consequences of the law, you can shake your angry fist and say it's not fair. I think I'd alluded to a while back getting pulled over. I was late to see my daughters and I got pulled over, and it was like, oh, why did that police officer dislike my children so much? Doesn't he know that I work hard and I want to see them?
Right.
I was breaking the law. I was pulled over and I was fined accordingly. The police officer was doing his job. So I could, if I wanted, I could choose to fight that and get someone to represent me and go to the court and say, here's all of the extenuating circumstances leading up to this. And the court would hear that. So the lie, the insidious part about this, right, is that the way a trustee gets paid, and I'd said this a little earlier, is that we're paid from the money that's in the estate, right? Now, whose money is that? Well, arguably, the citizen might say, well, that's my money,
Right.
because it's from the sale of their assets, or it's from the attachment to their wage if they make over that guideline. Well, you know what the creditors will say? The creditors will say, no, that's my money.
Right.
I get that money. Well, I think I talked about this in one of the last meetings we were in. How do we get paid? Well, we get paid out of the Bankruptcy and Insolvency Act, so we get paid out of that money. So the very first person to get paid is us. And what's our job? Our job is to monetize the assets. So do we have the individual's best interest at heart? Well, absolutely, because we're helping them access this legislation to restructure. Is our job to sell the assets for as much money as possible to the general public and get the money for the creditors? Absolutely. Do we get paid according to the work that we do? Absolutely. We get paid on a tariff, right? So a tariff means certain money comes in, we get paid out of it. So when someone says you ought to use, you should use somebody else besides a trustee. Well, there is nobody else besides a trustee. Like, that's the system that we've built. Now, you could hire legal counsel to assist you with something like this, just like you could hire legal counsel, when you get offered a job and you're offered a job to sign the contract. You could bring that to legal counsel and say, hey, I would like to have this reviewed. Or you could look at it and say, do I have faith with this employer? Do I have faith in this? Does anything seem untowards in relation to this? The concern I would have with a question like this is there's people within the community that just charge people money to be their representatives. They're not lawyers. They're not part of the legal community. What they are is they're people that have done some research and they feign to have the knowledge around the stuff, and they say, I will represent you. Definitely don't talk to a trustee without talking to me. I bought this franchise and I pay franchise fees to this company, and I will represent you and I'll find you a right trustee and I will charge you money. As I said earlier, the trustee is paid from money that's put into the estate. And what's so important about that, Taz, is that the reason why we're paid out of money that's in the estate and we're not paid outside of it, it's because it's to assure our independence as an officer of the court. So why would you deal with a trustee directly? Well, because we're the only one that you have to deal with eventually. If you are aggrieved by a decision that's made by a trustee, you can bring this to the attention of the Office of the Superintendent of Bankruptcy. So remember, there's like 1,000 of us. We're on a first name basis. So if there is a problem that you have with a trustee, you talk to the Office of the Superintendent of Bankruptcy and they'll investigate it for you.
Awesome.
Yeah.
That was cutting it nice and short. Thank you so much, Shawn. Thank you, everyone.
Thank you.
1 minute over. I've quickly just posted in the chat the other events that are coming up. We're on every Tuesday and Thursday evening, 7 p.m. Mountain Time. I put in a link to our blogs where we talk about a lot of the same topics that we're talking about here now. And then I put in a link for our contact phone number as well as our contact email. If you want to have a further discussion around this or look at, the options that are right for you or somebody that you know, this is how you contact us. Shawn, thank you so much for being here today. And our next webinar on Thursday, we're going to be talking about consumer proposals. So that'll be a really great one. Thanks, everyone. Have a really great night.